Hello, dear viewers. I'm George from Ireland. So this is another lecture about misrepresentation. So going a bit further, I'm going to first of all look at whether things are actionable, and then try and put things into different categories, and last of all, see the remedies that are available for the different misrepresentations. Um, so now the three different kinds of misrepresentation are, first of all, fraudulent misrepresentation, then there's negligent misrepresentation, and last of all, innocent misrepresentation. So fraudulent misrepresentation is tortious. It's a deceit at common law, whereas negligent misrepresentation is defined by the Misrepresentation Act 1967, and so indeed is innocent misrepresentation. If it's fraudulent, you are seeking to defraud someone, you are lying to someone, you know what you're saying is untrue. Whereas if it's negligent, you believe it's true or probably true, you just haven't bothered to do your homework and get it right, and it's your duty to get it right. Innocent misrepresentation is obviously accidental as well, but just unimportant, or you checked out and the information seemed to be correct. You said it, but actually the source you checked was wrong, and it was a reasonable source to check. So there's no default on your part. Remember, there's also negligent misstatement, and that's tortious at common law. Negligence is tortious. So anyway, let's dive deeper into fraudulent misrepresentation. So this means what you said was bogus, and you knew it was untrue, or you suspected it was untrue, or at least you were reckless as to whether it was true or not. And that's defined by Derry against Peake, 1889. Lord Justice Herschel sat on that case, and he had this following to say about it. He defined recklessness: a disregard for the truth. He went on, it's where a defendant has shut his eyes to the facts or purposely abstained from inquiring into them, just as fraudulent as if knowingly stated that was false. So that's the end of the quotation. So quite often they know that it's a lie. Sometimes they're not sure, probably a lie, but they go ahead anyway. So Thomas Witter against TPB Industries in 1996, Judge Jacob had that to say. Sorry, I was wrong. That wasn't Lord Justice Herschel. Okay, so more about fraudulent misrepresentation. This is a tricky one. It's difficult to claim this because you have to be able to prove it. You need quite strong evidence. Remember, this is a civil matter, so it's on the balance of probabilities, and it's up to the misrepresentee to prove that it was fraudulent. Anyway, so the court will sometimes ignore investigations made by the misrepresentee, as in S. Pearson against Dublin Corporation, 1907. However, once it's demonstrated that the representor really did say or do something fraudulent, then the reason he did it doesn't matter, as in Derry against Peake. Generally speaking, motive doesn't count. So there are major remedies for this, by the way. So let's look at negligent misrepresentation. So the Misrepresentation Act 1967, Section 2.1 says that this is where the misrepresentator will be liable for getting it wrong if he cannot prove that, and here's a quotation, he had reasonable grounds to believe it and did believe it up to the time that the contract was made, that the facts represented were true. Okay, so pause there. He believed it and didn't suspect it to be false. He honestly believed it. So therefore, and more that he had a good reason to think it was true. And remember that the onus is on the misrepresentor to prove that, first of all, he had a reasonable ground to believe it, and indeed he did sincerely believe it. Howard Marine against Ogden in 1967 is a case of this, so the fiction of fraud, because he was dealt with as though he'd made a fraudulent misrepresentation. So anyway, there must be a contract between the misrepresentor and the misrepresentee to take action on this, by the way. It should go without saying. Now let's delve into innocent misrepresentation. So Section 2.1 of the Misrepresentation Act 1967 talks about this one. So there's been a misrepresentation, as in a false statement, but the misrepresentor will get away with it if he can prove that he had reasonable grounds to believe it, and he did believe it, and that he thought that the facts he represented were indeed the facts and not falsehoods. So Hedley Byrne against Heller, 1967, is about this. And here, the about negligent misstatement, the claimant, who's the misrepresentee, has to prove that he relied on the misstatement and it was reasonably foreseeable that he would trust in that misstatement or would take action on that basis. Moreover, he has to demonstrate there's proximity between the parties. It can't be a negligent misstatement, which has nothing to do with his contract. Anyway, you have to also demonstrate, if you're the claimant, that it's fair, just, and reasonable to impose the duty on the person who made that misstatement, as in that's a false statement. Caparo and Dickman, 1990, is about this. So let's look at the remedies. Well, there could be rescission, as in you rescind the contract, and so the contract is ended for all intents and purposes. Now, you can get this for all types of misrepresentation. Remember, this is an equitable remedy, and therefore it's up to the discretion of the court whether they go with this or not. And they might say, no, in the circumstances that wouldn't be just.